सर्व न्यायाधीश तसेच शिवाजीनगर कोर्टातील तसेच फॅमिली कोर्टातील सर्व सिनियर वकील ज्युनियर यांचं मी प्रथमतः या ठिकाणी स्वागत करतो। आज आपण या ठिकाणी या नवीन कमिटीतर्फे मागच्या वर्षी जो आपण कायदा काढता ही लेक्चर सिरीज चालू केली होती त्याचं यावर्षी पुन्हा नव्याने आपण सुरुवात करत आहोत आणि त्याचं उद्घाटन आपण आपले प्रमुख न्यायाधीश श्याम रुक्मे साहेब यांच्या हस्ते करत आहोत। तरी मी व्यासपीठावरील मान्यवरांना विनंती करतो की त्यांनी प्रथमतः आपल्या कायदा काढण्याच्या माध्यमातून अनेक लेक्चर्स घेतले, जवळपास 30 ते 32 लेक्चर वर्षभरात झाले। याचा प्रामुख्याने फायदा नवीन जे ज्युनियर वकील आहेत त्यांना झाला। आपल्या दैनंदिन वापरामध्ये जो कायदा वापरला जातो तर या कायद्याकट्ट्यामध्ये त्याचे लेक्चर घेतले जातात आणि हे लेक्चर घेण्यासाठी आपण बाहेरून कोणाला बोलवत नाही वेगळं, तर आपल्यातलेच आपल्या इथं प्रॅक्टिस करणारे आपले जे काही सिनियर आहेत त्या सिनियरच्या मार्गदर्शनाचा आपल्या सर्वांना लाभ व्हावा यासाठी या कायद्याकट्ट्याचं आपण पुन्हा एकदा ओपनिंग करत आहोत। बोर्डाचं उद्घाटन होत आहे। बारच्या अध्यक्षा कल्पना निकम मॅडम यांना विनंती करतो। सिरीजचं उद्घाटन आणि पहिलंच लेक्चर आपले प्रमुख न्यायाधीश श्याम रुक्मे साहेब यांच्या होणार आहे। धन्यवाद।
उपस्थित सर्व ज्येष्ठ विधिज्ञ तसेच सर्व वकील वर्ग, गेले मागच्या कमिटीमध्ये 2024 ते 25 या कमिटीमध्ये ती फॅमिली कोर्ट लॉयर्स असोसिएशन तर्फे विविध तज्ज्ञांमार्फत आपण विविध कायद्यांविषयी लेक्चर घेतलेले होते। यामध्ये ॲडव्होकेट उपेंद्र खरे सर, ॲडव्होकेट अभिजित सरवटे सर, ॲडव्होकेट अभय आपटे सर, ॲडव्होकेट शिरीन मर्चंट, ॲडव्होकेट प्रीती परदेशी, अमजद खान पठाण सर, सचिन घाटे सर, निलिमा गोखले यांनी आपल्याला मार्गदर्शन केलेलं होतं। आणि या जे लेक्चर सिरीज आम्ही सुरू केलेले होते फॅमिली कोर्टामार्फत याच्यामध्ये विविध ज्युनियर वकिलांना मोस्टली त्याचा फायदा झालेला आहे आणि त्याच अनुषंगाने जे आम्ही नवीन कमिटी निवडून आलेलो आहोत आम्ही देखील असं ठरवलेलं आहे की या पूर्ण वर्षभर आपण विविध तज्ञ वकिलांमार्फत विविध कायद्यांच्या विषयांचे आपण लेक्चर सिरीज घेणार आहोत। यामध्ये प्रत्येक महिन्याच्या 2 मंगळवारी आपण तज्ञ वकिलांचे लेक्चर्स घेत आहोत आणि 2 मंगळवार जे आहेत जे आपल्याला कायद्याविषयी ज्या काही आपल्या अडचणी असतील त्याबाबत आपण चर्चासत्र त्याच्यामध्ये करत आहोत। म्हणजे 2 मंगळवार आपले संपूर्ण वकिलांबरोबर बसून आपले गट तयार करून आपण चर्चासत्र कायद्याच्या विषयावर घेणार आहोत। आता आज जो आपण हा कायद्याविषयी जो काही आज आज आपण इथे जे जमलेलो आहोत म्हणजे लेक्चर सिरीज ऑनरेबल रुक्मे साहेब यांनी आज आपण ह्यांचं पहिलं लेक्चर ठेवत आहोत। मला सांगायला अगदी आनंद होतो की सुरुवातच आपण आपल्या कोर्टाचे प्रमुख न्यायाधीश रुक्मे साहेब यांच्या मार्फत करत आहोत। वर्षभर हे लेक्चर सिरीज सुरू होणार आहे तर माझी सगळ्यांना विनंती असेल की सर्व वकिलांनी बेसिकली ज्युनियर वकिलांनी या लेक्चर सिरीजचा संपूर्णपणे फायदा घ्यावा आणि त्याबाबत आम्हाला सहकार्य करावं। एवढं बोलून मी अध्यक्षीय भाषण संपवते। जय हिंद, जय महाराष्ट्र।
धन्यवाद मॅडम। कायदा कट्टा ही लेक्चर सिरीज याची संकल्पना आपल्याचेच सिनियर ॲडव्होकेट अजित कुलकर्णी सर असतील, शिरीन मर्चंट मॅडम असतील, असे बरेच सिनियर यांच्याशी चर्चा करून ह्या कायदा कट्ट्याचा उगम झाला होता आणि त्याचा आपण वर्षभरात पाहिलं की किती लेक्चर झाले, त्याचा सर्वांना फायदा झाला। तर आज या वर्षीपासून हे पहिलं लेक्चर आज आपण स्टार्ट करतोय, तर ते लेक्चर देण्यासाठी आपले प्रमुख न्यायाधीश श्याम रुक्मे साहेब यांना विनंती करतो की त्यांनी द फॅमिली कोर्ट्स ॲक्ट या विषयावर आपल्याला मार्गदर्शन करावं।
President of the Pune Family Courts Bar Association, Nikam Madam, Vice President Prathamesh Boite and Smita Deshpande Madam, my esteemed colleagues, all the senior advocates. First of all, I declare that for year 2025-26, Kaida Katta lecture series has been inaugurated. Now, I will put disclaimer first before I say something. I am standing here in front of you as a student of law, not to teach anything to anyone but to learn myself and improve, so nothing wrong will happen due to my ignorance. Second disclaimer is that I was law student first, and today I am a law student and will remain a law student only, because title changes, designation changes, so permanently one tag will be there that I am a law student. Now, I must thank Honorable High Court for granting me permission to deliver my thoughts on the salient features of Family Court Act 1984. Second, I am thankful to the Bar Association for inviting me as a first guest for this lecture series. Coming to the topic, that is salient features of Family Court Act 1984. I could see senior advocates who are here since 1989. I joined this cadre only in 2011, so my experience is very short. Whatever I say is subject to correction, and don't take it as a final authority. If I was aware that so many people are going to attend this lecture series, I may not have accepted this invitation. So, why I said that I am thankful to Honorable High Court, because I sought permission and I would like to read the conditions put by Honorable High Court on me while saying something in front of this august gathering. After receiving invitation from your Bar Association, I sought permission to Honorable High Court. Honorable High Court was pleased to grant this permission on following conditions: that I should observe all norms of behavior of a judicial officer first. Second, you should not make any objectionable or controversial statement, and you should not speak about any pending litigation before you, dealt by you. So again, as an authority, I make it clear that whatever I say is not about any pending litigation or with which I have dealt with. Now, we are hearing that this is a family court. Just adjacent to our building, there is a big civil court, criminal court. We are all aware about this. I am not saying anything new. I must also share with you that one of the French scholar has already said that everything has been said earlier, but as no one listens, it is just necessary to repeat the same. So I may not say new thing, but I am trying to just put my views, how we stand different from any other court. So what is those salient features of the Family Court Act 1984? My job has become easy. I am not going to say many things about the act. Everyone has read the provision. Day and out we are applying, implementing and helping litigants to get the justice. Now I have just got this Code of Criminal Procedure. All are aware, there is nothing new. 484 sections. Now I will come to the CPC. 155 sections, 51 orders and scheduled appendices, all know. Now this is our Family Court Act 1984. Only 23 sections. See the wisdom of legislation, with what intent they thought it fit that this serious problem of matrimonial dispute can be resolved by this kind of enactment. 23 sections, almost 41 years are over, and in Pune, 89, since 89, we are in 2025. Yes, everything has been changed since 1989. Outer look has changed to lot of extent. Those who were practicing in that Bharati Vidyapit are well aware what kind of infrastructure facility this thing. Now this new generation has come. Now fortunate for them, they got very good infrastructure. Now this outer change will really help, or we need a inner change. Both are necessary, both are complementary, and both should go hand by hand. Now, the salient features of Family Court Act 1984, when we talk on this topic, we cannot ignore the special provisions provided under Family Court Act 1984. I forgot to share, we are running late, this little late from the schedule. Therefore, I will try to have one way this, I will not say lecture, one way opinions to restrict for some time. It will be more interactive sessions. We were told that law is a subject of discussion. On my own, I may say anything, I may interpret anything, but it should be able to accept by the opposite side or whosoever with to whom I am trying to convince. When we say it is a law is a topic of discussion, the discussion has to be with a view to learn, not to say right or wrong. So, matrimonial disputes is always a complex issue. Human mind is complex. Now, to solve the complex issue, whether we have to have the tools to resolve such issues of same complexity or simplicity, the answer is very simple. Simple procedure and simple solutions may have the great effect on the dispute or the problem, because every person is different. For every person, the definition of cruelty cannot be the separate. In 1955, when the Hindu, first 1954, when the matrimonial law regarding Special Marriage Act first was brought in force, the term cruelty was defined there. Thereafter, in 1955, Hindu Code Bill came into force, and the term again the matrimonial offence cruelty was defined there as one of the ground to dissolve the marriage. Since 1955 till 2025, there is no straitjacket formula to say which conduct may amount to cruelty or which may not. We are very well aware that, and there is a precedent also, that Honorable Supreme Court has already said in 1988 itself that no precedent can be applied to a case before us, because it has its own peculiar facts, background, social, economical and psychological also. So this matrimonial law or the Family Court Act 1984 was enacted keeping in mind the peculiarity, the diversity of our great country, because all the languages, culture is so different that it cannot be put in some words or defined to have an orderly society. To have an orderly society, we are well aware family institution is the basic institution. The role of women and children are very important for future of any country. Article 14, 15, 16 of Constitution of India allows Parliament and legislation to make special provisions. We are aware with this basic ground norms. We say Constitution is a ground norm. From there, the legislative try to solve the social disputes. Now, Family Court Act 1984 was enacted in 1984, considering the social conditions at that time. Now see how we all are aware the law is not static, but it is a change with the time. Now only two judgments. Recently, yesterday there was a Supreme Court judgment, Vibor Garg versus Neha. See how we interpret law, how we apply it, and how the real object of this Family Court Act 1984 can be achieved. Yesterday, Honorable High Court, our Honorable High Court said that the marriage is a spiritual union and no dispute can be prolonged to create a new problem. These are, see how decades consistent with the time the jurisprudence of matrimonial laws has been shaped by the Honorable Supreme Court, our Honorable High Court and other High Courts. So what is our role in dealing with such sensitive disputes? The answer is very simple, that if you open the preamble of the Family Court Act 1984, it says this Family Court Act, an act to provide for establishment of family court with a view to promote conciliation. Now this is the basic salient feature of Family Court Act 19, that we have to see the family institution shall be strengthened and first effort shall be for conciliation. If it fails in the preamble itself, the another object is to secure speedy settlement of dispute. I can't see councillors here. Bar Association said we wanted to invite. Okay, no issue. But the councillors, they are doing their duty. I am not there. But the first and foremost feature starts with marriage councillors. The effort was to try for conciliation. If that things happen, then this institution, means family court institution, can certainly strengthen. If not, then our roles comes in picture. Now, as I said, there are 23 sections. This entire building is outcome of this act. So whenever we come to deal with matrimonial dispute, I think it is a mandate of law that we should have some kind of initiative to help those litigants who are suffering or facing this problem. Now, why I am not reading further provisions? Because I find how important or how we should look at this enactment when we are talking about salient features of this Family Court Act 1984. Now, techno-savvy generation is there. They have so many apps with them. for getting any service, they change the app. They follow the procedure and they get the service. Now I think this example, or I will put it another practical example. If you go to the doctor doesn't start surgery immediately. He prescribes some medicines or some test. Subject to a result of that test or the medicine effect, then he changes course. Now, what has been we experience day and out? Criminal cases, civil cases are there. Today morning, our client comes in our court. His case may be pending for 2-3 years. He may have filed case for divorce. And if you ask him, give a time, he says, I want to take her back. Sometimes we come across cases where case is for restitution, and if the other side is ready, he says, I don't want to take back. Now, can there be any legal solution for this problem or his mood swing? There is a legal question involved in such cases where the mood or decision, I will say decision of the party has changed, and he has every right to do so, or she has every right to do so. No one can force, because marriage is basically personal issue, and it becomes social the moment disputes start. Till the happy married life, it is always a personal issue. The moment dispute starts, it becomes social, then it may be a legal also. The beauty of our court is this. I try to see what the solution for the problem. Of course, we all have to do that. The law, this Family Court Act, what we have to see how the same legal mechanism can be used to deal with the everyday problem, because there is nothing permanent in our dispute. Change is the only permanent thing. So many changes, judge has changed, advocate has changed, counselor has changed, the party is same. What's wrong in that? Because they are coming to this institution with a hope to resolve their dispute. Maybe counselors, it is a confidential procedure. We don't know what discussion is going on, and that discussion may not help us except to just see the decision of the party after attending counseling session. Now ultimately, our role comes then as a judge, as an advocate, or just to see what is possible solution. Now first and foremost, we all know it is a common when there is a lack of love, affection, transparency, trust, then and then such problem starts. In my humble opinion, the litigant who has lost the trust, the only solution is someone should take an initiative to build the situation, to make a such conducive atmosphere, so he starts trusting someone. First and foremost, everyone has to trust himself or herself. First, our duty is to see the problem may not be always legal. Problem may be economical, social, physical, mental, what not you say. I think first and foremost information comes to the advocate. How we use that data or information to deal with or tackle with that only couple first. If child is there, then there is a more responsibility on all of us. Because children are future of country, they are the real wealth of the country. They are not only family members, but as a citizen, they are going to contribute many things in future. So when we come with this access issue visitation right, and if we see the mechanism provided under the Family Court Act 1984, all these makes separate from all other courts. The only important thing, we all are human, there is no doubt about it. But we have to be more, have humanity. Litigant is hardly interested, sometimes he is hardly interested in outcome of legal proceeding. Because most of the time, the litigants' expectations are beyond this, our legal, these things. Sometimes we come across the examples where the need of the day is the priority, not outcome of the order of that litigation. In such situation, if we could be able to bring smile on that the litigant's face at least for that day, I think the object of Family Court Act 1984 is achieved. Not necessarily. Those who are here are not responsible for outcome of that case. Whatever is contributed, whatever is documentary evidence, oral evidence available with the party, they know much more than all of us. Section 21, and most importantly, I said, once Honorable Supreme Court has ruled down that Section 14 of Family Court Act prevails over all other laws, we don't have any right to discuss on that. So this is another salient feature to make a simple procedure regarding evidence. It has left to the conscience of the court to either to believe or admit or not believe on particular piece of evidence. Time is the most important aspect, not only for us but now coming generation. We know we have valued the time. The next generation is going to be different kind of this thing approach to cater needs of all the generations. The law is standing within that simplicity, but at the same time it provides solution or it provides tool to tackle any social issue for the coming generation also. Looking at this act only, we have to prepare the solution. As I said, there are so many aspects of any marital dispute, not only the legal issue. It is high need of the time to see that every day or every situation or every time there is no need to think legally. Of course, when I say so, that doesn't mean we can bypass the due process of law. The first duty is to understand the problem, whether it is social, legal, physical, mental, and accordingly we have to come with the solution. Now, as I said, the conciliation, to promote conciliation was the main object of this act. Now we have ADR with us. Now Honorable Supreme Court has come with another campaign, that mediation for the nation. Every now and then we look at the problem only through legal eyes. I think then that remedy may not be helpful to litigants. Their expectation, unless we understand the expectation of the client, whatever solution we provide, he may not he may not get satisfied. The reason are well known. only this marital dispute affects so many aspects. First and foremost, it, as I said, such litigants lost trust in everyone. They feel insecurity. It is but natural. The on whom he or she believed and they decided to have a partnership for entire life, that partnership is broken. Now they come with some short solutions or they have their own way of thinking. We cannot change their thinking, and we don't have we are not here to change what someone is thinking about their personal life. We have to see the mechanism, the tool provided under this act. I think if we just look at every provision which we are doing, actually this real object of this act can be achieved by teamwork. It's not the copyright of only one person to come with the solution, but unless and until we work as a team, this object of this Family Court Act 1984 cannot be achieved. When I say team, it includes counselors, doctors, sociologists, economists also, and all other professionals, those who are rendering their services to the society. Nowadays we come across many highly qualified litigants. They have their own expertise, they have their own career achievements. They feel proud of it, they have every right to feel proud of their achievement in a career. But we have to tell them, now this personal dispute or matrimonial dispute is much different than their career, what they have achieved in their career. If we say that there are only lacunas in our system, the client's faith is going to affect. Rather than finding lacunas in the system, if we decide to suggest solutions in a given system, I am sure entire society as a whole, their confidence will strengthen in our institution. We have to see, when this act was enacted, there was no fear or there was no apprehension that the problem will be solved and our this legal profession will be without any problems. This will never happen. I am sure so many people are not coming to the institution only due to misconception. There are so many misconceptions in society that court means dates, dates means uncertainty, uncertainty means there is no end, better sit across, take the law in their own hand and to create more problems. This we have to change, and if we have to change, the only solution is to follow the Family Court Act 1984 in letter and spirit. Because what this law gives to the society, it gives a simple procedure, it gives power to the court. Of course, power comes with responsibility, and it is a simple procedure which overrides all other procedures. It is procedural law. Basically, Family Court Act 1984 is a procedural law. It doesn't give any substantive right to anyone. When we talk about procedural law and substantive law, unless all this procedure is just to see that there is a fair opportunity to both the parties. If we focus on these all salient features of Family Court Act 1984, it gives every procedure to tackle any situation. When the people's confidence in the institution is strengthened, their mindset also changes. They become more open, they come with a more fair proposals. Maintenance, access, visitation are the maybe the interim orders, but it has lasting effect on the outcome of the entire proceeding. We are aware there is nothing new about these problems, but situations change, and particularly marital dispute happens. Every day is a new challenge. I will say it is an opportunity, not a challenge, to come back to the square where the journey started and look for a safe road where he can get happiness, peace. Choices, litigants, but ultimately, being a social issue, we all be somehow responsible for their safe journey in future. This act appears to be small, but if we read words in every section, I think it has one section may take 1 hour for its real object, intention of the legislation, and to deal with the problem. It is, we all know the views of society regarding family court. We should take it as a compliment, because when they say something about anyone or any institution, it is their personality, their expectation. We are not giving assurance that we are fulfilling all our we are here to solve all the problems, but at least we can be responsible not to create a new problem. So problems and solution will be always there. Considering the constraint of time, I will stop here, leaving this subject open for discussion forever. Not today. This is a beginning only. They decided to bring the batsman to face all the bouncers, and I took this opportunity. I don't mind to get out, but I would love to get the team win. So with this hope, expectation, and your this cooperation, I am sure soon, or we are making efforts to achieve the object of Family Court Act 1984, and we will continue our efforts to strengthen the confidence of society in our institute. I will say just 5 minutes. Those who wants to, I am not going to answer anything, but many people may have this queries and doubts. Just feel free to give it to me. Everyone will start thinking on that, and we will show the results through the actual working, not by the answers only. So this is not a question answer hour. Thank you everyone for listening. Every day you people argue, we get opportunity to hear, and today I was allowed to speak, and you listen patiently and set this task for me also. Thank you so much.
धन्यवाद साहेब. कायदा कट्टा लेक्चर सिरीजचं जोरदार ओपनिंग झालेलं आहे, आणि आपला जो बेसिक कायदा आहे द फॅमिली कोर्ट्स ॲक्ट, याच्यावर माननीय रुक्मे साहेबांनी अतिशय चांगल्या पद्धतीने आणि विस्तृतपणे आपल्याला मार्गदर्शन केलं. त्याबद्दल मी साहेबांचे वारतर्फे मनपूर्वक आभार मानतो. एक सूचना करू इच्छितो. या येत्या शुक्रवारी, आता ही फायलिंग आपलं कंपल्सरी झालेलं आहे, तर त्यासाठी येत्या शुक्रवारी ही फायलिंग प्रोसिजर यावर आपण एक सेशन घेतोय. तर ते सेशन शुक्रवारी आहे. एवढीच अनाउन्समेंट होती. यानंतर कार्यक्रमाच्या शेवटाकडे वळताना आभार प्रदर्शन 2 वाजता, दुपारी 2 वाजता शुक्रवारी, त्याचा मेसेज ग्रुपवर येईल सर्वांना. यानंतर या कायदा कट्टा या लेक्चर सिरीजचं आज ओपनिंग झालं. याचं पहिलं लेक्चर अतिशय जोरदार, बसायला जागा नव्हती, एवढा प्रतिसाद मोठ्या प्रमाणात भेटतोय आपल्याला, तर त्याबद्दल मी आपल्या सर्वांचे पुन्हा एकदा आभार मानतो. जर आजच्या लेक्चर मध्ये या कायद्यावर कोणाला काही प्रश्न असतील तर साहेबांच्या परमिशनने आपण विचारले चालेल. फॅमिली कोर्ट्स ऍक्ट
नाही, त्यांनी म्हणजे थोडा चेंज करतो. तुम्ही प्रश्न साहेबांना विचारत नाही, एका लॉ स्टुडंटला विचारताय. डेसिग्नेशन तुम्ही काढून टाका, ते त्याचा काही संबंध नाही आहे. जोपर्यंत आपण बोलणार नाही आणि कायद्याविषयी एखादा प्रश्न विचारणार नाही, तर मला असं सांगितलं होतं माझ्या गुरांनी, वाय, व्हॉट, व्हेअर, व्हेन हा प्रश्न आल्याशिवाय वकील वनच ना अवघड आहे. तर ते जर नाही आले तर मग त्याचा काही उपयोग नाही, आणि तसं नसेल तर मग काही प्रश्नच नाही लेक्चर सिरीजचे, असा अर्थ होईल. की सगळ्यांना सगळं येतं आहे म्हणल्यावर मग काही अडचण नाही. म्हणजे प्रत्येक जण रिसोर्स पर्सन पुढच्या लेक्चरला होऊ शकतं.
एखादी केस आहे 5 ते 6 वर्ष चालू आहे, ऑलरेडी पक्षकार झालेले असतात, आणि जसं तुम्ही म्हणाल लॉ ऑफ ॲक्शन आणि ट्रस्ट नाही तर मग रिलेशनच नाही. मग अशा कंडिशनमध्ये जेव्हा डिवोर्स आणि काउंटर क्लेम असे दोन्ही गोष्टी पॅरलल चालत असतात आणि जजमेंट दोन्ही डिसमिस असं होतं, तर मग मला असं विचारायचं की मग याच्यामध्ये खरंच म्हणजे तो ऑब्जेक्ट अचीव झालेला असू शकतो का पार्टीजकरिता, किंवा मग ते फेल्युअर असू शकतं का?
नाही, आता उत्तर द्यायचं नव्हतं, पण त्याच्यात लिगल आन्सर आहे म्हणून मी देतोय. एकतर असं आहे, जजमेंट झालं म्हणजे आपली फक्त रेमेडी आहे, आणि दुसरं गोष्ट आहे 6 वर्षे केस पेंडिंग आहे म्हणजे फॅमिली कोर्ट ऍक्ट फॉलो नाही झालं. येस, नेक्स्ट.
नमस्कार. कधी खरं म्हणजे साहेबांना प्रश्न विचारू नयेत असं लहानपणीपासून शिकवलं, पण आता साहेबांनी सांगितले की विचारा.
साहेब नाही,
आता साहेब नाही येत. एक गोष्ट अशी लक्षात येते की बऱ्याच केसेस ज्या येतात त्यामधल्या ऑलमोस्ट 40-45% लोक हे कमी जास्त प्रमाणात मेंटल डिसऑर्डर म्हणता येणार नाही, पण दे आर अफेक्टेड. आणि इफ दे आर गिवन सम हेल्प ॲट द राईट टाइम त्यातले डिस्प्यूट सुटू पण शकतात. फार पूर्वी एकदा हायकोर्टाला अशी आम्ही सूचना केली होती की आपल्याकडे ती प्रोव्हिजन आहे, आपल्याकडे ते सायकॅट्रिस्ट येतात सुद्धा, पण पुढे मागे ऑलमोस्ट एव्हरी मॅटर जसं काउन्सिलरकडे जातं तसं जर ते सायकॅट्रिस्टकडे सुद्धा जाऊ शकलं तर खूप मोठा फायदा होईल याला. कारण की ज्याला मेंटल प्रॉब्लेम आहे हा काही वाईट नाही. आता विराट कोहली जातो, दीपिका पादुकोण जाते, सगळे जातात. आता तर खरं तो स्टेटस सिम्बॉल झालाय सायकॅट्रिस्टकडे जाणे, सगळ्यांची जबाबदारी आहे. सो इफ यू कॅन परस्यू दॅट, मला वाटतं ते चांगलं होईल.
समाज आहे ना, ते आपल्याला वेड्यात काढायला येतो. आपल्याला वेड्यात काढायला खरं आनंद वाटतो जर खरंच तुम्ही शहाणे असाल तर. काही हरकत नाही त्याच्यात, शहाण्या वेड्याचा तसा प्रयत्न नाही म्हणत आपण. आजचं जीवनशैलीच अशी झालेली आहे की somehow we are ignoring mental health. Everyone. That's what I am saying. If I say anger issue to the litigant, I have to introspect whether I have the same. That the very moment decides the future course of the litigation. That when we talk about love, there should not be anger. And if there is anger, problem will multiply. It will never reduce. It will always multiply in many aspects. 498 is chalo DV restitution is there. Numbers are there. But आज मॅडम सांगितलं त्यांनी काय करायचं 6 वर्षानंतर. पहिली गोष्ट आपण 2 गोष्टी फिक्स करतो. लिगलला ओपन आहे ना, जजमेंट चुकीचं पण असलं तरी आपल्यालाच करावं लागेल. ह्याला काही मोठे हे गरज नाही, इट्स अ कॉमन थिंग आहे. प्रश्न असा आहे की त्यांचा प्रॉब्लेम पण त्याच्यातलं एकाला तरी डिवोर्स नाही मिळाला हे मी नाही. पहिली गोष्ट तुम्ही जर तसं म्हणत असाल तर 50% आपल्याकडं लोक सपोर्ट करणार आहेत, पण त्याच्या पुढे जाऊन what was the salient feature of this act is this winning and losing इथं प्रोव्हाइडच नाही आहे. What we are doing while implementing this beautiful enactment, we are focusing on winning and losing, when that is not the object at all. Win-loss may happen out of these premises. Here both can win, both can lose, or truth will win. First and foremost, we are not here for anything personal. The thing is that truth shall prevail, then and then rule of law will prevail. That we cannot run away from this basic responsibility, that we should make efforts to see which truth. We are not in that. Truth is that every litigant shall get their legal right. This is the only truth. I said every litigant. And that's what makes this enactment different. So many tools are there, but helpless, as senior advocate only shared with us, and it is a fact. I think what we are trained, I can share that basically. If you people get tired with 1, 2, 3 matter, see our mental health at the end of day. If yes, that's the only thing. Mental health is not this thing incurable. It is curable, but the experts are there, and it is, see how social trend changes. Earlier divorce was a stigma. Today only one of our colleague has shared that boy took bath with 40-liter milk because he got divorced. See the social trend. It is a fact. Yesterday only, one of the father took his daughter from matrimonial home with a band baja. We cannot shut our eyes to such kind of things, and then we will realize how important our role is. Here blaming will not help. Here only contributing good will help, and then good brings good. Otherwise it disrupts, and no mechanism or system can help to solve the problem. It just multiplies the problem. As I said, we may contribute to solve the problem, or we will be responsible for multiplying problems. So this is not about the outcome of the result of the legal proceeding. Don't relate all these things. And if you see, keep in mind the niceties of this act, and if you look at the problem in that way, sir said 45% cases will be reduced. I will say it will help to 70% cases reduced, but it will give rise to another 70%. I want to tell you the positive aspect actually. Don't carry the impression that we are losing the brief. 10 more people are waiting outside actually. If we could succeed to bring their confidence back, I am sure, and we, as I said, is services. This is not a service. Justice is not a service. Justice is much more than any kind of service. So our efforts are to see they shall get the justice. And justice is a teamwork. It's not copyright of one person. And everyone can contribute for the justice. So thank you. Good.
May I ask, with the thing that most of our clients, everyone must be facing, when they come to us, we understand one of them either is suffering from the depression or anxiety or some disorders, and even though we suggest them to go and meet psychiatrists, have some counseling sessions, they generally refuse, either they for themselves or for the saying that my spouse will not get ready for them. And shorter time, like within some time or afterward, we have to file a litigation before court, and we come to that how
beautifully the family court arrange a compulsory counseling session under such cases where one of spouse is suffering with some kind of, they need some kind of mental health, not necessary extremity of mental health condition due to some kind of mental health. We can certainly provide the psychiatric support over here. And other than that, the thing I like about it, when you differentiate between the civil court, criminal court and the family court. As we know, in civil court, the property matter may go on to the decades. Sometimes even a criminal cases go on for 10 years, 20 years. What I really think that if we could expedite the process or set some timeline for the matrimonial matter, it will really help the litigants to overcome the continuous anxiety. Because see, for us it is a matter, but when any lady or any male is facing this kind of litigations, prior to 3 days of the date, they start continuously feeling the depression, and even after 2 days, I should have said this, I should have done this, I should have done this. And when especially the kids are involved in this kind of matter, and when the date of access, visitation, the mental health of the litigation is hampering bad. So if we can do something where we can timeline the process, and if we are going beyond that time, then everyone, both parties should file some declaration that I will complete this process within this much of time. If we could do this, it really helps.
If matter and she ended with a suggestion. See the effect of if matter long gets this thing. First and foremost, thank you for reminding this to me. Actually, I forgot to tell. Whenever we go out, people know the identity. First and foremost question comes from them. How long it takes to decide family court matter? They come with the case. What is your answer? Answer is there is no need to go with, the answer is given in an act. Answer is given in an act by saying such cases shall be decided within 6 months. There is a provision. 21B, it says effort shall be made to decide the matter within 6 months. There is no discretion with anyone. We don't have any, this logic is different. But if someone asks me, yes, people do ask questions, they ask me. If I say, if all the works in letter and spirit, 6 months, I think at least we should not hesitate to tell the needy people or needy litigants, tell them the time stipulation. Who is responsible, everything is on record. Why to tell something else? Thank you.
थँक्यू सर. पहिल्या टप्प्याच्या मॅचमध्ये पहिल्याच बॅट्समनला आपण सर्वांनी जे बाउन्सर्स मारले त्याला अतिशय उत्कृष्टपणे साहेबांनी त्याला उत्तरं दिली. तर यातून नक्कीच आपल्या कायद्याचा विजय होईल असं मी आशा व्यक्त करतो आणि याचा सर्वांना फायदा होईल अशी आशा व्यक्त करतो. यानंतर कार्यक्रमाच्या शेवटाकडे वळताना आभार प्रदर्शनासाठी ॲडव्होकेट अमृता पवार मॅडम यांना विनंती.
आजच्या काळामध्ये लेक्चर सिरीजच्या उद्घाटनासाठी उपस्थित फॅमिली कोर्टाचे प्रमुख साहेब रुक्मे साहेब यांचे खूप आभार. तसेच माननीय ठाकूर साहेब, माननीय कदम साहेब, माननीय यादव साहेब, माननीय पाटील साहेब, माननीय गुले साहेब यांचे देखील खूप आभार. त्यांनी त्यांच्या अतिशय मौल्यवान वेळेतील वेळ काढून आजच्या कार्यक्रमाला उपस्थिती लावली. रुक्मे साहेबांनी आज आपल्याला अत्यंत महत्त्वाच्या विषयावरती फॅमिली कोर्ट ॲक्ट या विषयावरती मार्गदर्शन केले, त्याबद्दल त्यांचे खूप आभार. तसेच आज उपस्थित कोर्टातील माझे वकील बंधू भगिनी तसेच सिनियर्स ज्युनियर्स त्यांनी आजच्या कार्यक्रमामध्ये उपस्थिती दिल्याबद्दल सर्वांचे खूप आभार. आजचे कायदा कट्टा सिरीजमध्ये पहिले लेक्चराचा कार्यक्रम संपला असं मी जाहीर करते. खूप धन्यवाद.